summary judgment. The short version is summary judgment is a procedural mechanism, usually done by motion, where a court can throw a case out or throw part of a case out before it ever gets to the jury. And that's unusual. The important thing, the first thing to say about it is summary judgment is something that the judge decides. And having a judge decide whether a case can stay in court or not is unusual. Because we have a right in this country to trial by jury. It's in the 7th Amendment to the U.S. Constitution. So normally, in most cases, there is a right of both parties to have a jury hear the case. But sometimes, if one party believes that an issue is so clear that there isn't even any evidence on the other side of that issue, that party can ask the judge to decide. So the judge would decide on a motion for summary judgment whether to throw the case out or throw part of the case out. As we talk about this, I'm going to use an example where a defendant recently tried this on us. So I'll tell you a little bit about that case, and then we'll return to it and talk about it as we do this video. That case is an excessive force case against the city of Atlanta. Our client was tackled by some police officers where we believe he shouldn't have been, so we filed an excessive force case against the city of Atlanta. And first, I'll show you the video of what happened in this case.
Get out of the fucking car! There, police! Get out of the fucking car! Get out of the car now! Get out of the car! Let's go. Get out of the car. Get out of the car. Let's move. What are you doing, man? Tell me, what are you doing? You do not swipe my hands from me. Do you understand? That's the car.
So our client believes, and we believe, that that second officer who you saw run down the hill had no business tackling our client. In other words, that was not a reasonable use of force by the police officer. Nonetheless, the defense in that case filed a motion for summary judgment, claiming that it was so clear that that officer's use of force was reasonable that the case should have been thrown out. And that leads us to our second point, that usually on a motion for summary judgment, it is the defendant who seeks it. So usually the defense seeks summary judgment. And the reason for that is that in any personal injury or wrongful death case, the plaintiff has the burden of proof. That is, we have to prove what happened by a standard called the preponderance of evidence. So typically, when someone files a motion for summary judgment, what they're saying is that even if you believe all of the plaintiff's evidence, it's not enough. The plaintiff doesn't have enough evidence to win. Of course, we thought that was a terrible argument to make in this case because we believe that tackle so clearly should never have occurred. But the city of Atlanta filed a motion anyway. And it looks like this. Here's the entire pleading filed in the Northern District of Georgia in the federal court. And you can see here, this is the city defendant's motion for summary judgment and their brief in support, where, they say at great length all the reasons allegedly that tackle was supposed to be reasonable. And so they filed this brief saying, court, you should grant summary judgment. We respond in our brief, and we file our plaintiff's response in opposition to the defendant's motion for summary judgment. And then the court can hear oral argument on it. In state court, it's more common than in federal court. But the courts will read the briefs, and then sometimes the court will say, okay, let's have a hearing. We bring in all the lawyers, and we hear oral argument about it, back and forth in a real court. And then sometime after that, the judge will typically rule. And so that brings us to our third point about summary judgment. it is a long process. And it tends to be a long process for a few different reasons. First, before a motion for summary judgment can even be filed, the parties are supposed to have a chance to litigate the case and to do discovery, that is, to find out more evidence from each other about what happened out there. And typically, it's only after that evidence has been gathered that the defendant will then claim, oh, the plaintiff doesn't have enough evidence to win, which is exactly what they claimed in this case. That's what the city of Atlanta claimed when they filed this motion for summary judgment, trying to get our case thrown out. So the motion doesn't get filed for a while, and then once the defense files their brief, the plaintiff then has, depending on whether you're in federal or state court, 21 or 31 days to respond to that. Often there's a reply brief filed by the defense again, 21 or 31 days later most of the time. And then the court may hear oral argument on the motion. And even then the court doesn't usually rule during the argument. Usually the court will say, okay, thank you, I'll take it under advisement, which means the court's going to think about it a while and then write up their order, which is the final decision of the court on the motion for summary judgment. And I'll show you that too in this case, because thankfully the court denied the city's motion for summary judgment. In this one, we thought the motion for summary judgment was so bad that we asked the court to sanction or punish the city for even filing this nonsense. And the court did not do that, but the court did say, for the reasons set forth below, the defendant's motion for summary judgment is denied. And then they denied our motion for sanctions too. But this is a good thing. It means our client's case goes forward to the jury, which is exactly what needs to happen.